Welcome to the Renters' Rights Act. Don't get caught out. My name is Gareth. I am one of the trainers here at Society Matters. If you don't know me already, how dare you? My reputation precedes me. There is that lovely photo of me that I love so much in all of my cheeseburger glory, and I am going to be taking you through this little session this afternoon, all about the Renters' Rights Act and some of the changes that have now come into play. So, before we get into it, just a little bit of background about myself and about us at Society Matters, just kind of who we are and what we do, just in case this is your first time joining us, or maybe your first time in a while. So Society Matters is the trading subsidiary of Citizens Advice Gateshead. We are a KIC, though, community interest company. So what I do day to day is we deliver a range of courses on various different kind of social welfare issues. And we do try and feed the knowledge and the experience that we have as advisors into courses like this. But what's unique about us is that ultimately all of the profits that we make get gifted back to the charity to fund the various projects that the charity has, enable our wonderful advisors, some of who are on the call today, to do the good work that they do. And on the screen there is just some of the organisations that we're very proud to support and to work alongside. So just a very quick bit of housekeeping. It looks like you've done this already. Thank you very much, folks. If I can just ask you to keep your microphones on mute, just to avoid any kind of background noise. It can be a little bit off-putting while I'm talking as all. We're not going to be taking any breaks. We're only going to be here till about 3 o'clock thereabouts, so we're just going to power through. If you have any questions, hopefully you can tell I'm about as intimidating as a cold drink on a hot day. So if you have any questions, please do feel free to just take yourselves off mute or pop a message in the chat, whatever is easier. There will be time at the end, as I say, for a Q&A. What I'm going to do, so this session is being recorded. When we get to the end, I will stop the recording before we have that little Q&A. So if you don't want to ask while the recording is live, while it's happening, just hold your questions to the end and we can I'll answer any questions then. You will also get, like I said, you will get a copy of the recording and a copy of the slides a little bit later on. Within the slides themselves, you see there will be some links to a bit more information about what we are talking about this afternoon. So please do not feel like you need to just sort of sit and remember every little thing that I'm saying and commit it to memory. You don't. All right. So what are we going to be talking about for the next hour or so? So we're going to talk about this quite landmark piece of legislation that has now come into play, the Renters' Rights Act. What is it? Why has it been introduced? We're going to talk about the end of Section 21. Finally, about 6 years after it was first promised, Section 21, no-fault evictions, have now been abolished and been replaced to an extent by something else that we're going to talk about later. We're going to talk about how that changes the eviction process then. Now that the no-fault eviction process is gone, what does that leave us with? We're going to talk about the impact on private and social tenants as well. We're going to talk about the risks that that might create in terms of homelessness prevention. And we're going to finish things off before that Q&A thinking about how can we support clients under this shiny new system that we have. So, what is the Renters' Rights Act then, just to give us some context? So the Renters' Rights Act, formerly the Renters' Rights Bill, it is quite a major reform of the private rented sector. It does apply to the private rented sector at the moment. The intention is that eventually it will apply to the social rented sector, but at the moment it focuses very much on the private rented sector. And it is really, I would say, the biggest sort of housing reforms. Oh, no problem, Corinne. I've just seen your message there. No problem. They'll be getting a copy of the recording anyway. I would say it is probably one of the biggest, if not the biggest, housing reforms that we have seen in decades, quite honestly. Some of the key features that it sort of brings in and that we're going to be talking about, it abolishes those Section 21 no-fault eviction notices. Okay, they are gone. Bye-bye. It also introduces what we call periodic rolling tenancies. So it gets rid essentially of fixed term tenancies, and it does apply retrospectively. So if you previously had a fixed term tenancy, you will now be on a periodic tenancy, a rolling tenancy instead. Because Section 21 evictions have been abolished, it does now mean that if landlords want to evict, they need to prove what we call legal ground, something that we're going to talk about a bit later on, through something called Section 8 instead, as opposed to Section 21. Key reasoning, I would argue, behind the Renters' Rights Act is that, especially in comparison to other, say, European countries like Germany, we really have, or had, until this act was introduced, I would say, some quite weak rights around sort of tenant rights in particular. And so it's meant to, the Renters' Rights Act is meant to strengthen the rights that private renters have and give them more opportunity to challenge things like unfair evictions. Like we said, it does give them more rents, for example, things like requesting pets and so on, we're going to talk about later. Now, why does this matter? All right. Well, like I mentioned, it provides greater security for tenants. Historically, I would say if you think about the balance of sort of tenant rights versus landlord rights, very much I would say the scales were tipped in favour of landlords, and so the Renters' Rights Act tries to kind of redress that balance. It means, in theory, that there are fewer sudden no-fault evictions because they are gone, and it provides much more opportunity for that kind of early support and prevention, before people get to that crisis point. So, some of the changes then that have now been introduced. So these kicked in from the 1st of May, right? And it gave rather 11 million renters stronger rights, better protections, more security. So in terms of what has changed, all right, no more no-fault evictions. They are gone. They do not exist anymore. Like we've talked about, it does mean goodbye to those fixed contracts. So all tenancies in the private rented sector will have now become rolling tenancies instead, maybe month to month or week to week. It just depends on sort of what your particular tenancy agreement says, with no end date. Now that gives renters more flexibility. Tenants can end those with 2 months notice as well. It's also brought in additional protections around rent or rent increases in particular. So your landlord can now only raise rent once a year, and that's it. And it means that renters also can now challenge what they think may be unfair hikes through the courts if need be. Landlords now have to stick to no more than the advertised rent price. So you might have seen in the last few years there was a real increase in what I'm going to call, and you can see it on the screen there, bidding wars, where essentially you were applying for properties and saying to the landlord, I can give you this much rent in advance, or I can give you this much rent in advance. And now those have ended through this act because landlords can ask for no more than the advertised rent price and 1 month's rent upfront max. That's it. It is now illegal for tenants or for landlords, sorry, to discriminate against tenants that maybe receive benefits or have children. Sometimes you used to see those adverts like no DSS, meaning no one receiving benefits. It is now illegal. It is now classed as discrimination. It also, though, the Renters' Rights Act has introduced or made it easier for tenants to get pets, because you'll notice it says renters can now ask to live with a pet and landlords must consider it fairly. So the days of your landlord saying, no, sorry, you're just not having a pet, in theory, those have now gone because your landlord has to be able to justify why it is that you can't have a pet. So for instance, no, you can't have a pet because someone in the household is allergic, right? That's fine. But your landlord can no longer just say, no, you can't have a pet. They have to consider it, they have to justify it. Now, from the landlord's perspective, some of the changes that are going to be introduced, because like I said, the Renters' Rights Act, it's about balancing the tenant rights versus the landlord rights. So there are some changes that are meant to make it in some ways easier or safer for landlords. So the intention is that from later in the year, the government will introduce a private rented sector database. Now, that is a register of all landlords and rental properties in England so that you as a tenant can see who you are renting from. It is going to be gradually rolled out from later this year, showing who is renting out homes across England. Your landlord will have to be signed up to that database and they can be fined. It can be up to £40,000 if they are not a part of that database. It will also, the Renters' Rights Act, later in the year introduce something called the Private Landlord Ombudsman. Now that is to help renters sort out complaints against landlords quickly and fairly without the need to go to court. And it will create an independent person that will be responsible for resolving complaints against your landlord quickly and fairly. Now, the government, though, have said that they want to improve the conditions of privately rented homes because in terms of the building quality, Actually, we as a country, or the UK nationally, rank pretty low. We have some of, for example, the draftiest or the poorest sort of housing stock across Europe. So the government are legislating for that through the Renters' Rights Act. So, for instance, new rules will raise the standard of rented homes, so tackling damp, mold, dangerous conditions. Now, this is something that government have started to address through something called, you'll see it in bold on the screen there, AWAB's law. So for anybody who was not familiar, there was a little boy called Awab Ishak. He was about 3 years old, lived in a council property in, I think it was Rochdale, if I remember correctly, in a council property with his parents. And unfortunately, this little boy, Awab Ishak, he passed away simply through exposure to mold. The house was so moldy ultimately it killed him. And the parents had made repeated attempts to get it resolved by reporting it to the local authority. Nothing was done. Ultimately, this little boy passed away. And as you can imagine, it created absolute outrage that this could happen in this day and age in the UK. The government introduced something called AWAB's law, and what it's done is it's created legally binding timescales that social landlords, so this applies to social housing at the moment, it's created legally binding timescales that social landlords need to address issues like damp and mold and so on. The government's intention is that eventually AWAB's law will be extended to the private rental sector as well, but we don't anticipate that that will be for some time yet. But that is absolutely the intention. The government are also introducing new energy efficiency standards. So by 2030, your private rented home will have to be rated as an EPC rating C or better. That means that there will be better quality insulation. That means lower bills, greener living. When you think about things like cost of living and the like energy bills and so on, this is one way the government say that they are trying to redress that balance and make it easier for people. So, in fact, we've talked about that already, so we'll not rehash it. So, just as we've kind of run through things there, what are your first thoughts on the Renters' Rights Act? Do you think it's good? Do you think it's bad? What impact do you think it's going to have? Go on, who wants to rip the band-aid off? Do we think it's positive? Do we think it's negative? Do you think it might have some unintended consequences? Oh, I can just see people typing in the chat there. I'll give it a second. Corinna, you're saying 50-50. All right, I'm going to pick on you a little bit if I may, Corinna. Why do you say 50-50?
Although it does sound good,
Mhm.
I think what'll happen is a lot of landlords will think, I don't want to deal with this. And they'll sell up, which means there'll be less private renting houses, which will
Mhm.
put the country in a big problem with housing. And it's already in a problem with housing.
Yeah. Yeah, that is certainly the one of the consequences that's been raised, that these reforms, yeah, it's about making sure that your landlord is compliant or better, for want of a better phrase. But yeah, there will be some landlords who think, do you know what, I can't be bothered with the hassle. And then, like you say, they leave the rental market. That means that there's maybe a shortage of supply. There's already a shortage of supply when it comes to housing generally, I would say. And yeah, that just means, supply and demand. Does that then push up maybe rental property prices for other people, for instance? Lee, you're saying I think it's a good thing for private landlords to set up. The data at the minute shows the smaller landlords selling to the bigger landlords. Sorry, I can't talk. The smaller landlords selling to the bigger landlords who have enough money to have specific people employed to deal with repairs. Yeah, yeah, that is something, and you're absolutely right. That is what's happening. There was an article that I was reading the other day, and that is pretty much what's happening. The term they used was amateur property investors essentially are selling up because they've decided, you know what, I can't cope with this, or I can't deal with it, or I don't want to, or I don't have the time or the resources. And so they're deciding, you know what, I'll get out of this game. Yeah. Oh, sorry, I can just see someone saying positive, but saw an increase of Section 21 before they were banned. A lot of landlords won't want to be on a registry. Yes, again, I was reading an article in the paper the other week. So just before, and I mean even just like the week or two before the abolition of Section 21 came in on the 1st of May, yes, there was an increase in the number of Section 21 notices that were issued because it was your landlord's kind of a last chance to use that no fault eviction process. Now, if I'm honest, personally, and I stress completely my personal opinion, I'm kind of in two minds about that because the thing is, when you create a deadline, whether it was the 1st of May or the 1st of December or whatever it might be, I think to an extent that was always going to happen, regardless of when you do it. And could we say that maybe if those landlords are doing that and they're deciding that they want to sell up and not be a landlord anymore, is that a bad thing if the bad ones are going? Maybe. Again, just sort of playing devil's avocado there. A lot of landlords won't want to be on a registry. Yeah, they might not, but you know what? They'll have to be. They will have to be. If they're not, they can be fined. I think it's up to £40,000 if they don't join that registry once it goes live. I'm sorry, they don't have a choice. Agree with Corinna 50/50, thank you, Sophie. But I think until it covers all homes, including private and home office houses, there isn't a lot of social housing in most places. It's not going to have the biggest impact as they are probably wanting. Yeah, yeah, I can certainly see the logic there. I mean, like we said, things like AWAB's law, for instance, great that it applies to social housing, but what about the private rented sector? What about home office accommodation? Because that's going to take years. And in all of that time, where does that people leaving in those, cold, drafty, substandard homes, whatever it might be? I think as well, if landlords do sell up, it's going to cause more homelessness too, as people can't get social housing either. Yeah. So, like, a moment ago when I talked about the rise in the number of Section 21 eviction notices that were issued just before the abolition of Section 21 itself, those people are going to have to go somewhere, and if they can't, then, like you say, they're going to end up homeless. So that puts more pressure on local authorities, more pressure on homelessness services, and then where does that leave them? Mhm, mhm.
Can I say something as well, Gareth?
Of course.
So, you know where they said, obviously, they're making all landlords sound like the bad landlords as well. I think, because like I rent privately and my landlord's amazing. He hasn't put our rent up in 4 years and he's only put the rent up since this has come in.
Right.
So I don't
Right.
think it shows them on from both perspectives because they brought this in saying that like basically all private landlords are not as good as what they should
Yeah.
be. But I
Yeah.
don't think it should have that umbrella of it because not everyone's the same. I think you probably get more issues with some councils with social housing, with trying to get things resolved. I know from like my mum's perspective, my mum's been waiting to have a new boiler fitted for about 4 years,
Right.
and that's through a council property.
Uh-huh, uh-huh. Yeah, and I do again. I think that's maybe one of the sort of unintended consequences by bringing in this kind of regulation around things like that database that were mentioned and so on. It is treating all landlords like they are. It's almost like a prove that you're a, or we're going to think that you're a bad landlord until you prove that you're a good one, to an extent, if that's maybe the right way to phrase it. I mean, the argument is, if it drives out again, I'm going to say the bad landlords, is that a bad thing as such? But yeah, I can totally see why people have that impression because that's kind of what it can feel like at the end of the day. Yeah. Right. I'll leave it there then. So thank you very much for that, folks. Always nice to hear people's thoughts. So, where do we stand at this moment in time? So, we have here essentially the number of Section 21 evictions that were issued over the last 5 years. I'll just let someone in the chat there. So this is just a graph showing the number of Section 21 evictions that were typically received over the last 5 years. Now, to put it in context, there were about 32,000 Section 21 notices issued in 2024. About 11,400 households were removed by bailiffs following Section 21 evictions just between July 2024 and June of 2025. Now, 6,640 households were threatened with homelessness due to a Section 21 notice just in one quarter of 2025. 6,640 just in one quarter of 2025. We know and maybe this probably won't be a surprise to you, the use of temporary accommodation, sorry, it is at record levels. Temporary accommodation is eating up essentially more and more and more of local authority budgets, for want of a better phrase. 70% of landlords who evicted a tenant reported using Section 2021, compared with 26% using Section 8. So Section 21, we said, was that no-fault eviction, where as long as your landlord follows the right process, there wasn't really anything we could do to stop it. Where Section 8 evictions, your landlord has to show the grounds for eviction, the legal grounds, whether it's rent arrears or antisocial behaviour or whatever it might mean, right? Section 21 was historically the dominant eviction route because it was seen as easier. Now, why might that be the case? Because it didn't require evidence, because it was quicker, and because in a lot of cases it did avoid court hearings. Now, just because we've got rid of Section 21 evictions, doesn't mean that evictions have now ended. It just means that the process has changed. Right? So, what was Section 21? So Section 21, just for context, sorry, so it was introduced through the Housing Act of 1988, and it allowed landlords to regain possession without proving any fault on the tenant's part. So, the landlord didn't need to show the rent arrears, didn't need to show the antisocial behaviour, didn't need to show the tenancy breaches. As long as they served a valid notice, so, they gave people the correct notice period, they had protected the person's tenancy deposit, they had provided certain documents like the gas safety certificate or the ECP. As long as they followed the process, there wasn't really much that we could do in terms of stopping it. This was generally, it was much simpler than Section 8. Out of curiosity, how did we feel about Section 21 evictions? Do you think they were positive or a negative or a bit of both? Or do you think they were misused? Do you think they were a good tool? What do you think?
I thought they were misused, especially when the cost of hitting living crisis and the interest rates for mortgage rates shot up. I think a lot of and I can't really blame them, but a lot of landlords use the Section 21 when they couldn't afford their mortgage rates and they weren't prepared to go forward with regards to privately renting.
Mm-hmm.
I did
Yeah.
find, they are easier than Section 8 because obviously because of how easy it is. As it
Yeah.
says, it's no fault, so you don't need proof or anything like that. And a lot of it was issued. Sometimes your face didn't fit and a Section 21 could be issued.
Mm-hmm. Yeah, like we said, as long as your landlord followed the right process, there wasn't
Mhm.
really anything that we could do to stop it.
Yeah.
In that sense. And no, I do agree. I mean, there's that stereotype, I suppose, of, when you're paying your rent to your landlord, you're really just paying the mortgage kind of thing.
Yeah.
I mean, how true that is, I'll not get into. But that was certainly the perception. Yeah, that was something that we saw during things like the cost of living crisis and so on. It did have an impact because people thought, I can't keep this up, or I don't want to. But then where does that leave the tenants? Yeah. Hayden, you're saying it benefited landlords but not tenants. I think a reason for evicting someone should always be given. Yeah, call me a bleeding heart liberal. Call me a softie if you want. But yeah, I think Section 21, by and large, benefited landlords. If I can call a spade, much more than tenants. The idea that, no, I just want you gone. Just want you gone. And I, as the tenant, again, as long as they follow the right process, there's not really anything that I can do about that as the tenant. So, why was it abolished then? And we've kind of touched on these a little bit already. All right, so campaign groups, even places like Citizens Advice, have long argued that Section 21 just allowed people to be removed without any kind of wrongdoing. All right, because critics say that it contributes to housing insecurity, because how safe, how secure can you feel in your home if you could have been evicted at any point for no reason at all, no fault eviction? How safe can you feel that you are going to be able to stay there and build your life and put down some roots, or raise a family, or get a pet, or whatever it might be? It also was argued, and again, I think this evidence by and large bears this out, that no-fault evictions did increase homelessness, again, for the exact reason that we've just talked about. Your landlord wants you gone, and as long as they follow the right process, then I'm afraid you're gone. All right. So again, where does that leave that tenant who suddenly doesn't have a place to sleep that night? The argument for abolishing it was around calls for stronger tenant protections. So, like I said, in comparison to say other European countries, we had, I think they're better now, but we had quite weak tenant rights. Like I said, they were very much balanced more in the favour of the landlord than the tenant. And so Section 21 was abolished partially to try and reform that and to redress that balance. So these reforms, the Renters' Rights Act, they're about giving tenants greater security, but still allowing landlords to regain possession where there are legitimate reasons. Now, this is where your Section 8 evictions become much more important. So your Section 8 evictions, sorry, just for context, Section 8 evictions, so like we said, they are already available, and they were available even before Section 21 was abolished, but it was very different because with a Section 8 eviction, your landlord had to rely on specific legal grounds. So it could be rent arrears, it could be antisocial behaviour, it could be that the landlord needs to move back into the property, but then courts decide whether that possession should then be granted. All right, so the process, if you like, is far more kind of evidence-based and more complex, and so tends to take a bit longer. So, like we said, with Section 8, your landlord needs to show the legal grounds for possession. Now, there are two types of grounds. You've got your mandatory grounds and your discretionary grounds. So mandatory grounds, they give courts very little flexibility because if the landlord proves the ground, then the possession is granted. So that could be significant rent arrears, for example. So if you have more than, it's now 3 months rent arrears, then if your landlord can show that, then they have to grant the possession order and you could be evicted, for instance. So that means that the mandatory grounds are much higher risk and require, like earlier intervention to prevent escalation, particularly in rent arrears cases. Right. So ideally, we need to try and keep the level of rent arrears below 3 months. Discretionary grounds, as the name implies, it gives the court much more freedom to determine or to consider the full circumstances of the tenant, the vulnerability, do they have any support needs? Are they taking steps to resolve the issue, whatever it might be? The court can decide whether the eviction is reasonable. Now, what that means for maybe us as, say, frontline workers is that we have a much greater scope here to advocate for people rather, and present kind of supporting evidence. So we need to identify what type of ground is being used and at the earliest stage, because that is going to shape how we support that person. Anyone have any questions about anything at all thus far? No? Okay. So I want to take a second to talk about rent arrears in particular, and particularly how it relates to universal credit. All right, because rent arrears we know are a key reason that people are evicted, and previously might have been through Section 21, but now it's going to be much more through Section 8. So just to give us some context around rent arrears and UC claimants in particular. Research suggests that about 38% of landlords experience rent arrears from UC tenants. 29% had to evict a tenant in receipt of housing benefits or UC, with arrears being the primary reason. Right? Only 13% of landlords are willing to let properties to tenants on UC, partly because of fear over rent payments. This presumption, this stereotype that, well, you're on UC, so you know what, you're going to struggle automatically. They might be fine, they might struggle, but we don't know that. But it's that presumption, that stigma that is holding people back. But also it's about the policy itself. So if you're not familiar already, I imagine quite a few of you might be, but the amount of UC, the amount of housing element of UC that you get if you rent privately is affected by something called your local housing allowance. Now, your local housing allowance rates, they vary right across the country. But the thing with the local housing allowance rates is that they were frozen for several years. So imagine your local housing allowance rate stayed here for several years, and all that time, rents have just gone up and up and up and up and up. And so local housing allowance rates just haven't kept pace with the speed or the rate of rent increases. That has created, that is something we see every day, that has created significant shortfalls where the amount that people get in, say, the housing element of UC just doesn't cover the full rent. In 2023, 2024, thereabouts, the average shortfall for somebody on universal credit between the housing element and their actual rent was £157 a month. That was in 2023. Let's be honest, call a spade a spade. It's probably got worse since then. But also, like I said, thinking about the policy itself, that 5-week wait for your first payment combined with rent often being due in advance, it just creates an immediate fear for people claiming UC. So when you claim UC, best case scenario, you're going to be waiting 5 weeks before you get your first payment. Well, great, but I've still got rent to pay. Am I going to be in arrears before I even sort of get my first payment? How is that going to set me up? What's the relationship with my landlord going to be like if that's the case? I've moved into a property and applied for UC. I've got to wait 5 weeks for my first payment. I've somehow got rent to pay in the meantime. Where am I going to go? Am I going to need food? Can't talk. Am I going to need a food bank? Am I going to need to apply for charitable assistance? Am I going to have to borrow from friends and family? Am I going to have to use credit cards? How am I going to manage? So, just to kind of put it into context a little bit, so I've got a case study here, and this is before the changes around the Renters' Rights Act. All right. So we've got David. So David is 34. He's single. He lives alone, renting privately for 3 years. He has no rent arrears, no issues with the tenancy. But one day, he receives a Section 21 notice from his landlord. Landlord says that they want to regain possession. He is given 2 months' notice, and that is that. He's confused. He's anxious. He comes to you for support. He doesn't really know where to go or where he can turn to. So, can David challenge the eviction? What advice would you give? At what point can he approach the council as homeless? What do you think? Excuse me. Oh, I can just see Sophie typing in the chat there. I'll give it a second. If it's easier, folks, feel free to just take yourself off mute.
Would advise him not to leave the property until the bailiffs come, if he's going to take it that far, and to get in touch with shelter for support.
So don't leave the property until the bailiffs turn up. Yep, spot on. Get in touch with somewhere like shelter.
Yeah.
Anything else? Corinna, you've got your hand up there, sorry.
The problem with them not leaving until the bailiffs come is then they get stuck with all of the court fees.
Yeah. But then if he does leave before the bailiffs come,
He's
he
made
can,
himself voluntary homeless.
yeah,
And you
intentionally
can't,
homeless.
yeah, and you can't get support from the local authority then. Even the local authority, and it was on ITN when there was a mother with kids and she'd been issued a Section 21. She had to wait for the bailiffs to come, and then the bailiffs didn't come till late, and then she had to go to the council offices, which was closing. She had to wait in reception.
Yeah.
And she was advised if she'd left before the bailiffs, then she would have been making herself intentionally homeless, and she wouldn't have been able to get any support with regards to local authorities. So you cannot win.
You can't. I
It's
think the intentionally
ridiculous.
homeless as well, I think it's so unfair.
Yeah.
Like, I had a client last week who had fled domestic violence, and because she'd fled the country from domestic violence, she was making herself intentionally homeless by the council, which makes no sense. Yeah.
I don't know what to say to that.
No, it's
Honestly.
frustrating because, like, especially like in these cases when people have, like, if they are stuck,
Yeah.
then you kind of you're stuck in between, aren't you? You don't know whether what is best to leave or whether to stay. You can't win.
Yeah, Yeah, like you said, either you stay until the bailiffs turn up and then you're stuck with all the court fees and whatnot, or you leave early and then you're intentionally homeless and potentially you wouldn't get any support. And that's awful, especially if they were like fleeing domestic violence. You'd
Yeah.
like to think I'd be looking to challenge that personally. I
Yeah,
mean,
I
what were they
advise the
supposed
two.
to do? Just hang around
Exactly.
with the abuser until
Yeah, 32 years she'd stayed with him, and then finally had the last straw and left,
hmm
and then got
bless them.
told they couldn't get any help from the council.
Oh, brilliant. God. It's being recorded, so best behaviour, everyone. Right. But no, that is broadly what we want to say. So can he challenge the eviction? No, not really. In terms of advice I'd want to give, we can check the validity of the notice. So he's been given 2 months' notice. Okay, no problems there. But has he got his EPC? Has he got his gas safety? Has he got a copy of his how to rent guide? Has his deposit been protected? But assuming that that's all hunky-dory, not a huge amount we can do otherwise in terms of challenging the process. So yeah, I'd want to look at advising him stay in the property until bailiffs turn up because, like we've just talked about, he does run the risk of being declared as having made himself intentionally homeless. And then he can approach the local authority after that. Flip side of the coin, though, this is after the Renters' Rights Act has been introduced. So we've got James. So James is 42, single, recently lost overtime income. Renting privately for 2 years, 750 a month he pays. He's fallen into rent arrears of £2,250. 3 months. 3 months rent arrears there. Oh, no worries, Hayden. I beat you to it there. Great minds think alike. It's fallen into rent arrears, sorry, £2,250, so 3 months rent. Landlord serves a Section 8 notice on the ground of rent arrears. Court action is likely to follow. Struggling financially, now receiving UC. He is worried about eviction. Is the eviction likely to succeed? Is it a mandatory or a discretionary ground? And what support do you think could prevent eviction in that case?
Hayden here. So I would say it's definitely a mandatory ground because it's rent arrears. It could succeed, but it really depends on whether the landlord and the tenant are following sort of pre-action protocol on the steps they've made to try to bring back any rent arrears. Is there a payment plan in place? Have they discussed alternative options? Have they looked at support? Have they spoken to Universal Credit about an advance or whatever? Things like that. If they've tried all of the options and there's nothing and they're really not doing anything, then yes, the eviction would most likely be successful.
Yeah. So because he has 3 months of rent arrears, if he has 3 months rent arrears at the time of the court hearing, then yes, it is a mandatory ground. As long as the landlord can show that, then the court has to grant the possession order. If he can reduce it below 3 months rent arrears by the time of the court hearing, then actually it is no longer a mandatory ground as such, as long as he's below that threshold. So that is when, and I can see people in the chat saying it as well, you'd want to look at debt advice. So could he set up a payment plan? Like we said, could we look at a housing payment? Could we look at breathing spaces and so on? So is it likely to succeed, the eviction? Yes, it will succeed if he can't get it below that 3 months rent, that 3 months threshold by the time of the court date. It is a mandatory ground at this moment in time. In terms of the support that could prevent eviction, like we said, that would be things like could we look at like a payment plan with the landlord or some kind of debt advice, for instance. So, what do these changes mean for tenants there from the tenant's perspective? Right? It means that greater protection from no fault or retaliatory evictions, because no fault evictions by and large have gone now. End of. Which also ends that fear of retaliatory evictions. So, for example, what we sometimes used to see was you report your landlord for something and then they think, I'm just going to issue you a Section 21. And again, by and large, most of the time, if as long as they follow the correct process, not a great deal we can do to stop that. landlords now have to rely on those legal grounds that we have talked about. So things like rent arrears, maybe they want to move back into the property themselves, maybe there's antisocial behaviour. They need to rely on legal grounds and they need to prove it. Excuse me. Now, from the tenant's perspective, the court process itself, right, it provides more scrutiny to make sure that the landlord's doing everything that they're supposed to do. The flip side of the coin is that it will have the effect of taking longer. All right. So if you think about like court backlogs, for instance, does that mean that the court system is going to face that increased pressure because now more cases are going to rely on Section 8 evictions instead? From the landlord's perspective, right, it means that the challenges for the landlords is that essentially your landlord needs to be more careful with record keeping, with documenting everything. So things like your rent payment history, how much have you paid and when. It might change the way we communicate, or landlords communicate with tenants. If we've got to keep that record, does that mean we're going to be speaking to them more through like text or email where we can document what we've said and when, and as well as that, any evidence of tenancy breaches? Possession cases, in all likelihood, will take longer because of, again, court backlogs, because of the need for evidence, because maybe the court need to prove those, or we need to prove to the court rather those discretionary decisions. Right, that is just one reason why some landlords are concerned about the reforms, because of the additional burdens that it places on them as landlords. So, when it comes to supporting tenants facing Section 8 evictions, some things that we can do. One, bear in mind, early advice is essential. We want to try and support the person, before they even reach that crisis point, for want of a better phrase. But we can look at things like checking, has the right notice been issued? Have the right requirements been followed? Identify what possession ground is being used. Like we said, is it rent arrears? Is it damage to the property? And so on. And because once we know the grounds, we can then prepare our defence. Do we need to look at maximising income? So, for instance, a benefit check. Do we need to look at discretionary housing payments? Now, you'll see I put an asterisk on discretionary housing payments there. If you're not already aware, discretionary housing payments have changed slightly. Discretionary housing payments were available from local authorities, as the name implies, to help with housing costs. Could be used with things like rent shortfalls, for instance. As of about a month ago, or about 6 weeks by this point, as of the 1st of April, basically, strictly speaking, discretionary housing payments don't exist because they have been replaced instead by something called Crisis Resilience Fund housing payments. So the Crisis Resilience Fund, just the context, sorry, it was brought in as a replacement to the household support fund that existed a few years ago. But the Crisis Resilience Fund is meant to be more kind of long term. So where the household support fund kept getting extended every couple of months, the Crisis Resilience Fund is going to operate. It's operating right now for the next 3 years, but it incorporates discretionary housing payments. So strictly speaking, discretionary housing payments, DHPs, don't exist. If you want a housing payment, you need to apply to your local authority through the Crisis Resilience Fund for a housing payment. In practice, they are very much the same. So they are still discretionary, no guarantee of an award, and they are still time limited. The only real difference is the process, if you like, where once upon a time you would apply for a DHP to your local authority. You would now apply to your local authority, but through the Crisis Resilience Fund for a housing payment. Evictions, though, evictions are not ending. They are just changing shape, is the take home, really. We've got rid, for want of a better phrase, of Section 21, no-fault evictions, and some people might say that's a very good thing, but that's not to say that there won't be evictions anymore, of course. It's just that they will become much more kind of evidential and process-driven. So, when it comes to working, excuse me, When it comes to working with the Renters' Rights Act, all right, in terms of maybe us as frontline practitioners, all right, we need to build our understanding of the Section 8 grounds, and we do have some resources that I'm going to point you to in just a second. Build our understanding of Section 8 grounds so that we can support people with that and apply it in practice. We need to focus on early intervention, because with Section 8, of course, now we've got your sort of your mandatory versus your discretionary grounds. It does change the way that we can support clients by giving them time to maybe build that defence, for instance. Right? It means that we can support people around things like rent arrears, affordability, and improve engagement with landlords now that there is that process. Now, when it comes to supporting clients, like we've just said, right, that early action is going to be absolutely crucial, because the earlier we can deal with a problem, the less likely it is to ever reach that crisis point rather, sorry, and hopefully maybe say prevent homelessness, for instance, particularly when it comes to things like rent arrears. Right? The Renters' Rights Act, it doesn't introduce new responsibilities and new rights for tenants themselves that they might not even be aware of, actually. Because I will say there's one thing, if there's one thing about this government, I'll tell you, it's that they're not very good at communicating the things they're doing. So it might well be people have these new rights and new responsibilities, but do they actually know that they have them? All right. Now, as well as that, right, clients themselves, we can support with things like evidence and the documentation, because now that Section 21 is gone, for all intents and purposes, we have a much more evidence-based procedural system. So can the client, collect their evidence? Can they document things? Like we said, how do they communicate with the landlord? How do they pay the rent? Do they get evidence that they've paid the rent? And so on. What's really important, though, is trying to plan ahead to prevent homelessness in particular, and avoiding those crisis situations. At the end of the day, we're moving really from sudden evictions to much more evidence-based systems, and that's where rules like ours are going to become even more important. So, in terms of key takeaways from today, key message, the Renters' Rights Act, it has kicked in, took effect from the 1st of May. But some of the changes that we talked about, they do go into 2030 and beyond for some new regulations. So Section 21 is now abolished. It is gone. Section 8 is now the main eviction route, meaning that possession is going to require legal grounds. And so our understanding of the system and our clients' understanding of the system is going to be absolutely critical, because the system has changed. The key message, like we've said, is that we're moving from that sort of simple notice system to a much more evidence-based system. And to be frank, that's going to affect absolutely anybody that has any skin in the game when it comes to housing, whether it's tenants, whether it's landlords, whether it's us as advisors, whether it's local authorities, whoever it might be. Understanding things like Section 8 will become increasingly important because of the changes that this Renters' Rights Act has introduced. So on the screen there is just some resources that you can use to find out a little bit more about the Renters' Rights Act and the changes that are coming in. As I said, you will get a copy of these slides shortly after the recording. You'll notice they are hyperlinked, so you can just click it and it will take you straight to it. All right. Now, if you are interested and you want to find out a little bit more, I will say, Society Matters, we are very proud that we actually have two courses related to housing, homelessness. One is our kind of older housing and homelessness course, CPD accredited full day, and it looks at the support available to people experiencing what we call housing insecurity, so different types of tenancies, the Section 8 eviction process, homelessness eligibility, and welfare benefits that are linked to support people with housing, and crucially, how can we support vulnerable clients facing any kind of homelessness crisis. In this course, I will say it has been updated in light of the changes around the Renters' Rights Act. Separately to that, though, we also have a new session that we are offering. So this is a full day, again, CPD accredited course all about supporting people with homelessness applications. So it deals with the homelessness application process in particular. So how to make an application, understanding the duties that local authorities have, priority need, vulnerability, challenging gate people, challenging decisions where we think maybe incorrect decisions have been made as well. If you want to find out more, you will get a link to our website in that email. You'll get a little bit more and you can find some more information there. So that does bring us to the end of the session. We've got about 10 minutes. Does anybody have any questions about anything at all?